People sometimes ask, what is ineffective assistance of counsel? Hopefully, I can answer that question in this short video. The Sixth Amendment of the United States Constitution guarantees every criminal defendant access to meaningful and effective legal representation. Because of this right, every defendant is also afforded an opportunity to challenge that their counsel wasn't constitutionally adequate. This is done by presenting a claim of ineffective assistance of counsel to a court. A court can only find that an ineffective assistance of counsel when an attorney failed to provide the sufficient representation guaranteed by the Sixth Amendment. This legal finding is usually different than the perspective held by a defendant. For example, the defendant may equate a guilty finding to ineffective counsel. A guilty verdict alone does not mean counsel was ineffective. Rather, a defendant must specifically identify where and how counsel underperformed. To help guide a determination as to whether or not counsel was ineffective, the United States Supreme Court created a two-part test. The test is found within a case titled Strickland v. Washington. Using guidance found within Strickland, reviewing courts have a common standard to apply when considering a defendant's claim of ineffective counsel. This test is used regardless of whether an attorney was court-appointed or privately retained by a defendant. The first part of the test in Strickland is known as the performance prong. This portion of the test requires a court to determine whether counsel's performance fell below an objective standard of reasonableness. What this means is, how would other lawyers who were faced with that same situation represent the defendant? If other attorneys would have performed in a similar manner, then there wasn't deficient performance. This analysis must be premised on the attorney's action or inaction made at the time that the challenged decision or event occurred. Review cannot be made using hindsight. For instance, a client's defense which inevitably fails does not mean the defense wasn't viable when it was chosen. If the strategy or tactic was sound when pursued, it subsequently cannot be found deficient. However, if the strategy or tactic was made without any investigation, but with minimal research, the chosen action or inaction would have been different, then there was deficient performance. Merely establishing a lawyer's approach was poor performance does not yet win an effective assistance of counsel claim. A defendant must also prove that some harm or prejudice actually occurred in the case. Under the Strickland Test, this second requirement is referred to as the prejudice prong. To establish prejudice, a defendant must prove that absent counsel's deficient performance, there is a reasonable probability that there would have been a different outcome to the challenged event or proceeding. As an example of a possible claim, consider a defendant who alleges counsel was ineffective for failing to file a motion to suppress evidence. The defendant must prove that it was deficient performance not to file that motion, and if the motion had been filed, it would have won the day in court. Every defendant must prove both elements of the Strickland test before a court will find that counsel was ineffective. The failure to satisfy either component of this test will be fatal to every ineffective assistance of counsel claim. I hope that you found my description regarding ineffective assistance of counsel helpful. To learn more, please visit www.barkanresearch.com.